case representing 16 youth plaintiffs has brought hope and inspiration for a just transition away from fossil fuels and the protection of the West's natural heritage. So to introduce our two speakers, we have Barbara Chilcott, and Barbara is a senior attorney in WELC's Rocky Mountains office in Helena, Montana. Originally from South Carolina, she earned her bachelor's in economics from the University of North Carolina, Chapel Hill, and her JD from the University of Montana School of Law. She spent the first 15 years of her career focused on water law, working to restore in-stream flows across Montana. She served as a legal director for the Clark Fork Coalition and later as a staff attorney for Montana's Department of Natural Resources and Conservation. And since joining WELC in 2021, Barbara's work has centered on climate and energy-related litigation to halt the environmental impacts of fossil fuel development. And then we also have Melissa Hornbein on the call, and Melissa is also a senior attorney in our Rocky Mountains office. She holds degrees in botany, anthropology, and a master's in environmental studies, as well as a JD from Hastings College of Law. And before practicing as an attorney, Melissa worked in the field as a botanist, biological technician, and various academic and governmental entities, including the National Park Service and U.S. Geological Survey. And she worked as an attorney with the Montana Department of Natural Resources and Conservation on tribal and federal water rights issues, and as an assistant U.S. attorney in Montana with the Department of Justice. And Melissa joined WELC in 2020, where she focuses on climate and energy issues. So thank you, Barbara and Melissa, and everyone for joining us today. I will hand it over to you guys to get started.
Thanks so much, Michelle, and thank you all so much for joining us today. I'm just going to share my screen here. We have a little presentation to share. How does that look, Michelle?
It's in presenter mode right now.
Still in presenter mode. Okay, how's that?
There we go. Perfect.
Great. Okay. Great. Well, thanks again for being here. Melissa and I love to talk about the Held versus State of Montana case. We were very privileged to be a part of the legal team bringing this case on behalf of the 16 youth plaintiffs. We recently received a very favorable decision from the Montana Supreme Court last December. And so we're going to talk today about just a little bit about the case background, the trial court decision from August of 2023, our recent Montana Supreme Court victory, and then the backlash that we're already starting to see here in Montana from both the executive and legislative branches, just to highlight that the Held decision, while very impactful and groundbreaking and historic, is just kind of beginning and continuing the fight for a stable climate here in Montana and elsewhere. So first, just a bit of background on the case. Many of you have probably heard a lot about this case. It received a lot of attention, or it still does. But the case was filed in March of 2020 on behalf of 16 young people in Montana. The attorneys representing the youth plaintiffs in this case are with Western Environmental Law Center, where Melissa and I here are, and another law firm in Montana called McGarvey Law, and then our Children's Trust, which is an organization based in Eugene, Oregon, which is really working to bring constitutional youth climate cases across the country. And so with that legal team in place, we looked at the state of Montana and realized this place was ripe for a constitutional climate challenge. And the reason for that is, as you can see on the photo on my left, that is an image from Montana's 1972 Constitutional Convention. Montana has one of the strongest constitutions in the nation in terms of environmental protection. And the constitutional delegates, the intent in drafting our Constitution was to provide the strongest protections of any state constitution for the environment. And so with that backdrop, combined with Montana's basically uh, outsized impact on climate change from our development of fossil fuel resources across the state, including coal mines, refinery operations, and the like, uh, there was a kind of a perfect storm of a state that is basically, or has basically, bent over backwards to promote fossil fuel extraction at the expense of the environment. Again, part of the Constitution, this is kind of highlighting the framework and the foundation of the Constitution. And this is the preamble, which says, I'll just read it, it's pretty remarkable, that we, the people of Montana, grateful to God for the quiet beauty of our state, the grandeur of our mountains, the vastness of our rolling plains, and desiring to improve the quality of life, equality of opportunity, and to secure the blessings of liberty for this and future generations, do ordain and establish this Constitution. That language is provided kind of the backdrop to really important constitutional provisions that we grounded our case in. And that is, those constitutional provisions provide for the fundamental right to a clean and healthful environment in Montana. And so under Article 2, Section 3 of the Constitution, the right to a clean and healthful environment is part of our Declaration of Rights. It's fundamental to each of our citizens of Montana enjoying the environment and being protected from its degradation. And in addition to recognizing the right, the Constitution also provides an affirmative obligation for not only the state, but each person shall maintain and improve a clean and healthful environment. And the legislature must provide adequate remedies for the protection of the environmental life support system. So given this backdrop, and then what we knew about the state of Montana, in that they basically have never seen a fossil fuel permit that they didn't like, and indeed in testimony at trial, the evidence showed that the state of Montana has never denied an application for a fossil fuel permit in Montana. So we were able to develop this case with these young people in Montana who each individually in their own right, even the smallest ones have, now that they're grown up a little bit, are doing their part to address the climate crisis in their own ways. And so these plaintiffs are from across Montana. They were as little as 2 when the case started, and now are as old as 23, I believe, is the oldest one at this point. There was only one plaintiff at the time who had the right, who was 18, who had the right to vote. The rest of the young people were unable to vote. They were all minors at the time, and part of the goal for them, it was to just say, we have no other ways to influence our state government. We can't vote, we can't lobby, we don't have money to, lobby our elected officials. We need a place that we can go to enforce our rights to a clean and healthful environment. And in this case, that was the court. The defendants in the case were the state of Montana, the Montana governor, and then several state agencies. The primary state agency implicated in this case was the Montana Department of Environmental Quality. That agency is responsible for all environmental permits in Montana, whether it's water related or clean water quality related, mining, oil and gas, a lot, and coal mining, along those lines. So with the Constitution as our kind of foundation and the young people as the plaintiffs, we crafted a complaint that was filed in March of 2020, right around the beginning of the COVID pandemic, as many of you, probably all of you, remember what you were doing around that time, and there's a lot of uncertainty in the world. The complaint was about 100 pages long. It goes into extreme detail on the harms that each of these plaintiffs have experienced as a result of climate change. The complaint also details the state of Montana's actions in promoting the climate or promoting fossil fuel extraction that exacerbates the climate crisis. And it also goes into um, the laws that the state operates under to kind of fulfill their perceived mandate to promote fossil fuels. The case, we ended up challenging two different statutes, two different laws in Montana that were really implicated in promoting fossil fuel. One is the state's, many of you may have heard of the National Environmental Policy Act. Well, most states have their own kind of mini NEPAs. In Montana's case, it's called the Montana Environmental Policy Act. That law, part of that law, basically said to state agencies that you are forbidden from looking at or analyzing greenhouse gas emissions or climate change when looking at permit applications for fossil fuels and other activities. And so we challenged that statute explicitly, basically saying that that statute as written violates the plaintiff's constitutional rights to a clean and healthful environment, because because the agencies are not allowed to look at climate change and therefore are not allowed to take steps to prevent unnecessary degradation of the environment to protect the plaintiffs. There was another statute that we challenged as well under Montana State Energy Policy Act, but that statute was repealed by the legislature right in the middle of our litigation, which kind of brings me to the trial that we had in June of 2023. And so between the filing of the complaint here and the trial, it was a little over 3 years. And so in that time, there was a lot of stuff going on. The state at every turn tried to stop the case from going to trial. And our ultimate goal was to bring this case to trial so the youth plaintiffs and our expert witnesses could testify in open court about the harms caused by climate change, that the state of Montana bore a responsibility, and that the plaintiffs had been harmed. And so getting to trial was quite a battle. Each of the older plaintiffs were deposed by opposing counsel for the state. And those, if any of you have ever sat through or witnessed a deposition, those can be fairly stressful. And so there was a lot of kind of working with the plaintiffs to prepare, and then to just, feel comfortable throughout the process. And so, that happened. We prepared a ton of reports for with our expert witnesses that served as the basis for their trial testimony. We kind of fought back motion after motion from the state to try to stop the case from going to trial. We ended up at the Montana Supreme Court twice in order to prevent the state from having the Supreme Court take over the case from the district court. And each time the state was unsuccessful. And so we arrived at trial in June of 2023, and we had a 7-day trial. We put on our witness testimony from the older plaintiffs and several of our expert witnesses. And it took about the better part of a week of the 5-day trial week. And the state put on 3 witnesses, and their case took about 2 days. And so the trial we'll discuss a little bit here. Each day coming into trial in Helena, the community just came out to support the plaintiff. So this is an image of the youth plaintiffs walking into the courthouse on one of the trial days, and just an example of the community that came out to support the plaintiffs and the work. It was pretty cool to live here in Helena and to be kind of a part of this community, be our community that helped really support these young people as they bravely came to court and told their stories. Just a couple of examples of the testimony from the plaintiffs. This is Olivia. And Olivia testified to the harms that she experienced from climate change, as that manifested in terms of her anxiety, her worry about having children with the climate crisis as part of that backdrop. She is an artist, as you can see, and she brought her art into court and showed everyone and discussed how this art represents her climate anxiety, and just spoke so bravely and eloquently about her story and her fears for the future and the harms that she had experienced just living in this world with smoke-filled skies and Montana summers, and trying to navigate that. Another plaintiff is Micah here. Micah had several of the plaintiffs were very nervous about testifying in court, and Micah was one of those. He was so very steadfast in kind of his position. He had done a lot of climate advocacy himself. He had written letters since he was about 8 years old to his congressman to really try to spark action on climate change. And he's a runner. He suffers from asthma as well. Micah lives in Missoula and has had impacts from wildfire smoke to his running, and which exacerbates his asthma. And he also just thinks really deeply about this issue. And I think that's what really came out in a lot of these stories from the plaintiffs, is that they are really so thoughtful about about where things stand. They understand what's happening to the climate, and they understand the risks and the need and the urgency to kind of act as quickly as we can. And you could just feel that in their stories. And so I'm going to play just a clip from Micah's trial testimony, just to kind of give you a sense of what it was like in the courtroom and kind of the impact from the stories here. So you may have to turn up your volume to hear. Oops. It's smoky. How about the words to write in the photo? That's a poem I wrote. Can you kind of describe the circumstances around when you wrote this poem? Yeah, recently the rest of my family got COVID, and so I had to quarantine in our basement for many days, and it was too smoky outside for me to go outside at all. I was just stuck in our basement for days. I've been living in quarantine in my basement for a week now, separated from my family because of COVID-19. Cooking, eating, schooling, alone. I have another week to go. I just found out that pandemics are more likely to occur with a changing climate. And now I can't even go outside to play because another fire started near my home. It wasn't the first time, and it won't be the last. According to the experts, the smoke from the forest fires make our air too toxic to breathe. And the fires will only get worse, they say. Yet the climate crisis is only getting started. I'm a prisoner in my own home, alone and wondering, what is my future?
is their own. Why is no one listening? Do they not care? Well, I hope that people try to make a difference, and I hope that the state of Montana can change their ways and protect the citizens of Montana and meet the fellow plaintiffs.
So that was just an example, just to kind of give folks a feeling of what it was like at the trial and kind of in the room. Micah's was one of many of the plaintiffs who just sat up there and testified in open court, a situation that is terrifying for a lot of us, I think. And they were just so honest and brave and compelling. And so I'm going to pass it to Melissa now, and she's going to kind of go into the expert testimony and how we were able to kind of tie that to the experiences that Micah, Olivia, and the other plaintiffs shared.
Thanks, Barbara. So as Barbara just demonstrated with that incredibly moving clip of Micah's testimony, this case, and particularly the trial, really turned on storytelling and the ability to convey to the court a very compelling storyline. And luckily, we had these amazing youth plaintiffs who had so much courage and poise and were willing and able to get up there and tell the court their stories. And they were, like, beyond question the most effective part of the trial. But in order to meet the legal standard, we also had to prove our case. And for that, we needed not only the plaintiff's account of how they're impacted by climate change, but also we had to prove the following basic facts: that climate change is happening and how it happens, that Montana is contributing to it, and that the state has both the authority and the technological ability to respond in a different way that would actually have an impact on the problem. And the reason we had to do this, as Barbara alluded to when she was talking about the complaint, was that the state denied every allegation that the plaintiffs made in that complaint, including the basic fact of anthropogenic climate change. And that was both, I think, pretty staggering to us, but also provided us with this really unique opportunity to tell for the first time, to kind of give the soup to nuts of climate change science and the economics and science and health impacts of climate change for the first time in a judicial setting in front of a court. So for trial, in order to make the plaintiff stories sort of as effective as they could be, we paired them with expert testimony that supplied the data and the science underpinning the types of injuries that the plaintiffs talked about in their testimony. And those included, as Barbara alluded to, stress from respiratory impacts from smoke, such as Micah and other plaintiffs who have respiratory issues experienced, heat stress, recreational impacts from decreasing stream flow and decreased snowpacks, cultural impacts, economic impacts to plaintiffs whose families depend on farming and ranching for their way of life, and psychological harms. And for that purpose, we had this incredible group of 10 expert witnesses who volunteered their time and skills to help the youth plaintiffs illustrate their stories with the scientific, economic, medical, and cultural facts that were necessary for them to bolster their case to the court. And leading off this expert testimony were two climate scientists. First, Dr. Steve Running, who is a Nobel Prize winning climate scientist based, he's retired now, from the University of Montana in Missoula. And he really just explained the basics of climate heating as a result of anthropogenically released greenhouse gas emissions into the atmosphere. And that's what this graph demonstrates. It's called the Keeling curve for those of you who aren't familiar with it. It's just showing the increase in atmospheric carbon dioxide over time from the 1950s or thereabouts to the present day. And in addition to that, he did something that was really critical for the court, is he established that there is a baseline threshold for a stable climate system, and that is 350 parts per million. I just caught an error. I never managed to do a PowerPoint without having at least one error. That should be parts per million, not parts per billion, of carbon dioxide. And by way of context, in the pre-industrial age in around the 1850s, the level of carbon dioxide in the Earth's atmosphere was around 280 parts per million. Now, or at least as of the date of trial, it was 450 parts per million. So we have blown by that stable climate threshold. But one of the things that Dr. Running testified to is that we have the ability to get back there. And if we can get back there, we can stabilize the impacts of climate change. Following Dr. Running, Dr. Kathy Whitlock, who's a professor from Montana State University, and is a lead author on both the 2017 Montana Climate Assessment and a bunch of subsequent state-issued reports on climate change, as well as a lot of pioneering climate research, testified that Montana has warmed disproportionately to the rest of the country. And for those of you who live in mountain states like Montana, this probably isn't news. Those mountain states, states that have generally a higher elevation, higher latitude, colder climates, are being disproportionately impacted by climate change relative to the rest of the country. And as Dr. Whitlock testified, those impacts have economic repercussions. They have impacts on the state's water supply. And Barbara, if you can switch the slide. Our next witnesses, who were two earth scientists, talked about specifically those water impacts. Dr. Dan Faegre is a retired glaciologist from Glacier National Park. He worked for the U.S. Geologic Survey for 30 plus years studying those glaciers. And as we can see from these pictures of Grinnell Glacier, which is the second largest glacier in Glacier National Park, between 1938 and 2008, that glacier went from being massive to being essentially a snowfield with a bunch of icebergs, which now are gone. The glacier is still hanging on, it's still there. And part of the reason for that is that it's north facing. The north facing glaciers, unsurprisingly, are doing better than many of the others. And Dr. Faegre also testified to the fact that at the end of the Little Ice Age in 1850, there were approximately 150 glaciers in Glacier National Park. As of 2022, there are only 25 named glaciers left. So he really laid out exactly how glaciers are, quote unquote, climate on the landscape. But they're more than that. They're also what are called water towers. They are water storage devices that help amplify the impacts of winter snowpack, which then becomes critical for summer stream flows, agricultural water, fisheries, and basically people existing in Montana. And so those water towers that the glaciers exemplify are part of the hydrologic cycle in Montana. And that entire cycle is adversely impacted by climate change, both in terms of the fact that there is simply less water, there's less precipitation that falls as the climate warms, and that more of the precipitation that does fall occurs as rain on snow events. So it doesn't help bank that water supply in those water towers for later use during the hot months of the year. Next slide. Following Dan Faegre and Jack Stanford were our health witnesses, Dr. Lori Byron, who's a pediatrician, and Dr. Lise Van Susteren, a psychiatrist who specializes in climate change impacts on people's mental health, testified to two really important aspects that went directly to many of the injuries that plaintiffs here have experienced and are experiencing. So Dr. Byron initially talked about why children and young adults are disproportionately impacted by climate change. They are uniquely vulnerable because of their age, because of the still developing nature of their bodies, particularly their lungs and brains, to the types of extreme climate events that climate change has made much more frequent. And in Montana, of course, the big ones are air quality. Our wildfire season is approximately 80 days longer than it was about 30 years ago. With that comes many days of smoke, heat stress, water quality and quantity, and social impacts from stratification across socioeconomic classes. And then Dr. Van Susteren spoke to the mental health impacts that the plaintiffs here and youth like them are suffering as a result of climate change, some of which Barbara mentioned, specifically plaintiffs, including Olivia, as well as others, agonizing over the question of whether to have children and bring another generation into this heating world, their anxiety about the future, anxiety that is exacerbated by having to stay inside when there's day after day of smoke or high pollen counts. So Dr. Van Susteren spoke to those types of impacts. Next slide, please. Next, we had two witnesses who spoke first to the cultural impacts of climate change. And in particular, we had youth plaintiffs who were Native and members of tribes within the state of Montana, including Sariel depicted here. Michael Durglow is head of the Tribal Preservation Department of the Confederated Salish and Kootenai tribes of the Flathead Indian Reservation in the northwest corner of Montana. And he has also done a lot of work with the reservation's youth and climate change issues. And he testified about how cultural practices are being lost as a result of climate change. And one example that he gave was specific stories that have to be related from older to younger generations at certain times of year. And in some cases, they can only be related, for example, when there's snow on the ground. And if there isn't snow on the ground at the right time of year, those stories don't get passed on. The elder generation dies out, and the younger generation never gets to directly access those stories from the preceding generation. Sariel also testified during her individual testimony about impacts to hunting and gathering habits that her family has practiced for her entire life, including harvesting sweetgrass, harvesting huckleberries, and the impacts that she's seen as a young Montanan on those natural resources as a direct result of climate change. Following Mike Durglow's testimony is that of Ann Hedges. For those of you who have done work in Montana, I'm sure you're familiar with Ann. She is the executive director of the Montana Environmental Information Center, and she is an environmental and policy activist who has decades of experience with Montana's fossil fuel-based economy, the legislature, and the fossil fuel permitting system in Montana. And she really brought home for the judge and the court just how much the state of Montana has known for how long about climate change impacts and the dangers it poses, and then the actions that state regulators, legislators, and leadership have taken despite having that knowledge to double down on a fossil fuel economy. Next slide, please. Our next two experts testified to Montana's impact on global greenhouse gases and the feasibility of switching from a fossil fuel-based economy to a renewable energy-based economy. First, Peter Erickson is a greenhouse gas accounting expert, and yes, that is an actual field. And his testimony was really important because the state had repeatedly made an argument that, hey, climate change is a global problem. Montana by itself is such a tiny state. We're such a small part of the problem. Even if we stopped all of our emissions tomorrow, which we can't do, it won't have an impact on the global problem. And Pete Erickson testified that not only is that not true, but Montana has a disproportionate impact on global climate change. We emit or are responsible for the emission of about 166 billion metric tons of greenhouse gas emissions or CO2 emissions annually. And by way of context, that is the same amount of emissions as a number of countries, including Argentina, the Netherlands, and Pakistan, all of which have a population of about 200 million people, and Montana has just surpassed 1 million. So we really do have a disproportionate impact, and he strongly undercut the argument that the state was making that, hey, this is a global problem, nothing we do can actually affect it. Following Pete Erickson's testimony was Dr. Mark Jacobson. He is a Stanford professor and the world's leading expert on renewable energy transition. And he testified that not only is it possible for Montana to meet all of its energy needs from renewable resources, it is technologically and economically feasible for it to do so right now. Like, the technology exists, we have it. And Dr. Jacobson's testimony was really critical and led explicitly to a finding of fact in the court's decision, stating that, hey, it's technologically and economically feasible for Montana to make this transition. The only bar to that happening is politics, political and social resistance. And I think it's hard to overstate the significance of seeing a fact finding like that in a judicial opinion. So next, I'm going to show just a brief video clip of Pete Erickson's testimony. Here in the clip, he's responding to the state's economic expert and an argument that that person made about carbon offsets. So Barbara, if you could go ahead and play that. Can we try and get the sound? I'm not sure what's going on. Sorry. I'm still not hearing sound, Barbara. I'm not sure if you are.
I'm not. It's Michelle.
Are you all, is no one hearing sound?
No, no, I wasn't either.
Okay, interesting. Let me.
Micah's also started off this way and then the sound kicked in. I'm not sure. There we go.
You could hear it?
I think so.
Okay, let me try again.
Thank you.
It might just be the beginning. That's a little bad quality of sound.
Okay, let me go back.
There we go. Good. But, oh, now it's gone now. Do you think it's because you're on mute?
That's great. Like, there's no, they should be rewarded or, praised in some way for that. However, this statement, I need to take Mr. Anderson's use of the word offset on face value here, because offset means something in climate and greenhouse gas accounting, which is my area of expertise, right? An offset is something that you buy or commission in a marketplace to credit against your own emissions. There are ways of doing that legitimately. What he's describing is absolutely not one of them, right? He's saying that, again, if taking the words literally, that Montana should get to credit reductions relative to some imagined emissions that it didn't emit against its own actual emissions. Now, I'm sorry, but I have to try to use a metaphor here because it's so preposterous. I like cake, but a lot of people here like cake. Imagine I have a piece of cake and I eat that piece of cake. It's delicious. And imagine I really want another piece of cake. There's another piece of cake sitting in the kitchen. I don't eat that piece of cake. What was my cake consumption today? 0. 1 piece of cake plus a negative one piece of cake, zero cake. That's great. So that is, you can't offset your own emissions against something you didn't do. If you didn't do that thing, that's enough credit in its own, because that should have reduced your actual emissions or
and as to whether Montana can offset.
I think we're starting over. Barbara, if you can, thank you. So at the conclusion of trial, after the conclusion of trial, about 2 months later, we got what are called the findings of fact, conclusions of law and order. This is basically just the district court's opinion after hearing all of the testimony that was submitted at trial. And again, as Barbara referenced, the plaintiffs put on a full week's worth of testimony, 5 days. The defendants about 1.5 days total. They put on 3 witnesses. So it was ironic that the state did not admit to a single allegation in the plaintiff's complaint, and yet almost all of the allegations, particularly about climate change and just the fact of anthropogenic climate change and how it happens and the economic impacts, they put on no testimony to rebut. So it was just, it played out in a very interesting way. The court's findings of fact, there were 289 of them, and many of them were direct quotes or things that had come forth in testimony during the trial. And so, it's hard to like pick one thing as the most significant, but I think the sort of fundamental message of this decision was that, yes, Montana's right to a clean and healthful environment does, in fact, include a right to a stable climate system. But beyond that, and as I mentioned, thanks to the state's inability to admit to basic scientific facts, we had the opportunity to really put climate change on trial, and it came out in this order and the conclusions of findings of fact, conclusions of law and order in an incredibly articulate and compelling way. I don't generally advise people to go read district court opinions, but this one is worth a read if you haven't read it. It's 103 pages long, but it's just incredibly compelling. And I think that's where the utility of this case comes in other states, even in other countries, which don't necessarily have a comparable constitutional protection to what Montana has, because all of that climate change science, all of that, the renewable energy facts, all of the economic and health facts are just set forth, and they're set forth in a public document that people can now use. And that is a big piece of the utility of this case beyond the state of Montana. Of course, the state then appealed that decision to the Montana Supreme Court. So just shy of a year after Judge Seeley issued her decision in August of 2023, we had oral argument before the Montana Supreme Court in July of last year. And then just before the holidays on December 18th, the Montana Supreme Court issued its decision resoundingly affirming Judge Seeley's findings of fact and conclusions of law. But the decision is not significant only for that. Of course, that's incredible. And that was really everything that we had hoped for, was just a straight affirmance of the district court order with no narrowing, no qualifications. So we kind of got everything we hoped for, but the court actually went further. It issued this beautifully written opinion, just discussing in great detail and with incredible force the strength of this constitutional provision. And I'm just going to read this provision from this section from the opinion. We reject the argument that the delegates intending the strongest all-encompassing environmental protections in the nation, both anticipatory and preventative for present and future generations, would grant the state a free pass to pollute the Montana environment just because the rest of the world insisted on doing so. Montana's right to a clean and healthful environment and environmental life support system includes a stable climate system, which is clearly within the object and true principles of the framers' inclusion of the right to a clean and healthful environment. Now, this language has generated a lot of backlash from various folks in Montana, in particular, members of the legislature and elected officials. None of this was surprising to us, but it is telling just how far we have come, or I guess maybe how far we have regressed from 1972, when we had this incredibly forward-looking group of constitutional delegates who drafted that right to a clean and healthful environment, who explicitly said this is an inalienable human right, and the state and each person and the Montana legislature has an obligation to uphold this right. Like, it doesn't get a lot clearer than that to this kind of rhetoric. And it's disappointing and it's frustrating that we don't just get this decision and like that's the silver bullet for Montana. But the reality is that it's not. The fight continues, and we are going to keep fighting most, I guess, most pressingly right now before the Montana legislature, where there are multiple efforts to undo what the Montana Supreme Court did and held, most notably by decoupling MEPA, the Montana Environmental Policy Act, from the constitutional provision. Luckily, we have the held decision from the Montana Supreme Court. We have prior Montana Supreme Court precedent that tells us that the constitutional protection is not dependent on MEPA. And if the legislature isn't going to rely on the Montana Environmental Policy Act to ensure that this provision is protected, then the substantive permitting statutes had better do so. And I think that's the fight that we're looking at now, is taking challenges to substantive permitting statutes under the Montana Clean Air Act, the Clean Water Act, and various other environmental provisions, and carrying this decision forward. And so, in the words of Pete Erickson, directed at our legislature, let them eat cake. We are going to keep bringing the fight. And with that, we have, I think, a few minutes for questions. Thanks, everyone. You're on mute, Michelle.
That would help. Hey, I just wanted to say thank you so much for all of that and all that you do for the climate and all around for us. So we had a couple of questions come up in the chat, but I just wanted to remind everyone to feel free and just raise your hand or unmute yourself. I think we're a small enough group that you can go ahead and ask your question, and we have a few minutes for that. So I will go back to one of my questions in the chat. Bill was wondering, do you expect this case to be duplicated in other states? And if so, do you think this decision will affect future decisions?
Barbara and I are both waiting each other out. This is a question that comes up a lot, and yes, but I guess is the easiest answer. Montana is one of only 6 states that currently has what's called a green amendment, or the type of constitutional protection that we have the right to a clean and healthful environment. So the approach in other states is going to be different. There have already been a number of lawsuits filed by our partner group, Our Children's Trust, in other states. Most notably, they just got a really favorable settlement in the state of Hawaii, which does have a similar constitutional protection to ours. But I think sort of the next logical step is that in both our case and the federal case, the Juliana case, as well as a number of other cases that Our Children's Trust has brought, there are other claims beyond just that clean and healthful right. There are due process, equal protection, right to privacy claims. And so I think in expanding this case beyond those 6 states that have those types of constitutional protections, we're going to need to be looking at those other fundamental rights that are much more common, both in the federal and other state constitutions. Barbara, do you have anything to add to that?
That was perfect. Thank you.
Here's a question you might fight over who's going to field. How's the weather in Helena? But
I'll take that. It's sunny outside today and cold. We have snow on the ground. It's been a pretty mild winter though, so far.
Another question in the chat. This is a bit adjacent to your work with Our Children's Trust, but do you think these rulings might have an impact on the movement to sue fossil fuel companies for damages related to climate disasters?
I'll start. I am fascinated by that movement. I think that work is so appealing. It is a different type of case, of course, that a party would bring against a fossil fuel company. Usually those are, based more on kind of common law principles, requiring a ton of kind of evidentiary works and a lot of trial work, a lot of trial prep, a lot of expert witnesses. But I mean, and so that's just kind of like the nitty gritty and the weeds that I get into when I think about these cases. It seems that the case that, like, as Melissa described, Judge Seeley's order at the district court, the findings of fact in that order are so compelling and really provide kind of a little bit of a guide for other courts and other parties to prove climate, one, that climate change is happening, and two, who's responsible. And I think you could take kind of that playbook and transfer it to these other types of cases. And so I think, we all learn from each other in this world, and we definitely anticipate the work that has been done and held can definitely be transferred over to suing fossil fuel companies for their harms. Melissa, what would you like to add?
I can't, nothing to add. That was a great response. Michelle, do you want us to just go from what's in the chat?
Yeah, I was like, if that's easier for you to read, you can go ahead and go for it. I know it's kind of hard to do these rapid fire ones. So also if folks had questions, you can feel free to just shoot us an email after the fact and we can follow up with you too. But yeah, go for the chat, Melissa.
Sure. So to address the one concerning international human rights, we did not specifically plead international human rights in this case, but there is a really close interplay between sort of the fundamental inalienable rights under the Montana Constitution pled here, those in the Juliana case pled at the federal level, and many of the types of rights that are being pled in international cases currently, including the Klimas-Signorenin case from the Netherlands, the cases that are currently pending before the International Court of Human Rights concerning island nations disproportionately impacted by climate change. So I think that there's a lot of interrelationship. I recently did a panel with a bunch of international climate change attorneys, and this issue came up of sort of the UN enumerated international human rights. I think they all fundamentally kind of stem from the same recognition that there are basic inalienable rights that human beings enjoy, and whether those rights are enshrined in a state constitution like that of Montana, in the US Constitution, or in international documents as is controlling in these other cases. So I would say that there's not direct overlap in the specific claims being made, but there is an incredible amount of overlap in sort of the subject matter and the basis for the arguments that are being made, that people who are impacted, and particularly those who are disproportionately impacted by climate change, need to be protected and need to have their rights vindicated.
Thank you so much, Melissa. And I know we're about at time, so if folks had other questions that you wanted to ask, you can feel free to shoot them my way and I can pass them along and try and get those answered for you. But I just want to be conscious of everyone's time. And one last thing, I just wanted to say congratulations to our raffle winner. It is Susan Habig. So Susan, I'm not sure if you're on the call still, but we will follow up with you to get your stainless steel cup to you. And then just overall, I wanted to say thank you to Barbara and Melissa again for all of your work on this. And much gratitude as well for everyone on this call. All of our supporters are a huge reason why WELC can operate, and our attorneys like Barbara and Melissa can do the critical work they do is thanks to our supporters. So much gratitude all around to everyone, and just thanks for showing up today. And yeah, I will put my email real quick in the chat in case anyone needed to follow up. It's just loth@westernlaw.org. And Melissa and Barbara, I didn't know if you had any final thoughts or thanks or anything.
No, I really appreciate all of you being here. It's really nice to see support. It's really important right now to have community, and I just feel really hopeful whenever so many of you are interested in the work we do. And so thank you.
Ditto. Thanks everyone for taking the time out of your days. Really appreciate everyone's interest in this. It's a critical time for it.
Ditto that. Well, thanks again, everyone, and have a great rest of your day. Bye.